And I wanted to introduce myself. My name is James Long. I'm the owner of Regnum Legacy, which is an estate planning law firm here in Southern California. And you could say that I kind of got my start in estate planning and in this business after my grandfather died. I saw the trust, although I was quite young when he died. I knew that he died with a trust and he died with a plan, and I noticed how easy that was, or seemingly easy that was, on my grandmother. And if you fast forward to a time when I was in law school and actually studying these subjects, the area of estate planning really appealed to me because it called to mind those memories of my grandfather's death and how an effective estate plan could help heal a family and help provide for a family. And so I started my sort of career as an attorney as an estate planner. I've been doing estate planning for 10 years, but I was doing it the wrong way. And I didn't even know I was doing it the wrong way because, laws is always about monkey see, monkey do. And so I just did what other estate planners were doing. I did what I heard on CLEs and things like that. And so what that meant was I was trying to get the best forms. I was trying to get the best intake system down so that ultimately I could produce a pile of documents that would be an estate plan for my clients. At the same time, I was also working for a firm that was doing litigation. And so for 6 years, not only was I doing estate planning and sort of transactional business stuff, I was also doing litigation over failed contracts and failed estate plans. And I noticed a commonality in each one of these failed estate plans. And the turning point was a particular case. It was a 9-year litigation, and I came in just about at the 5-year mark. So I spent the next maybe I came in at the 4-year mark. And I spent the next 4 or 5 years completing this litigation. But the litigation started 25 years prior when the mother of my client saw an estate planning attorney. He drafted a plan for her and subsequently never followed up with her, never checked in to see if her plan was still working. And it's tragic because, as it turns out, her plan wasn't working. And so what she did along the way, as many lawyers might be familiar with, is she amended the plan herself. And at each successive amendment, the plan got more and more convoluted and, frankly, a lot more confusing. And it's that confusion that caused the $2.5 million estate to be whittled down over the course of 9 years of battles between the siblings, caused it to be whittled down into just under $100,000. At the end of the day, the plan didn't work for her because she didn't get what she wanted. The court did not enforce what she wrote in her amendments. Number 2, her family hates each other. None of the siblings talk to each other because some fell on one side about what this particular amendment meant and what should be done, and others fell on the other side. And her entire estate was practically eaten up in attorney's fees and court fees because the trust itself had to hire an attorney to defend it. And so I looked at that experience and I thought to myself, of all the plans I had done, every client I served, I never went back and I never checked in. And I was worried. I was worried that it was malpractice. So I started calling the state bar. I called the ethics hotline. I called other estate planners. And what did they tell me? They told me, well, does your client engagement letter have an end date? Does it have a specific scope of services, and did you complete those services? I answered yes, of course I did. I said I was going to do these documents, and I did the documents. And then the next question was, did you send a terminating letter? And I said, of course I sent a terminating letter. And as far as the state bar was concerned, and as far as my fellow estate planners in the industry were concerned, that was it. My obligation was over, and it just didn't sit well with me. Because what I'm thinking is malpractice is actually common practice. And there's stories like this all along the way. Another turning point was I had my kids. When I had my kids, I started reflecting on what would happen if I died. and they were at home with a babysitter. And the scary proposition crossed my mind that they would be taken into the custody of Child Protective Services because the babysitter I left them with has no clue who to call in an emergency. You see, the estate planner was left without a plan. And I made a resolution that I would never leave a client without a plan, and I would never leave a plan without an attorney. So we follow up with our clients regularly. Every 3 years they get a checkup. We craft a plan for minors, parents with minor children, not just long-term guardians, but short-term guardians, and we create a kids protection plan for them. This is why I do what I do. I started as some kid who witnessed the effect of an estate plan on his family. A kid who knew nothing about the law, but who could see the tangible effect that that would bring. And then, from there, as a young attorney, doing what every other attorney does, playing the monkey see, monkey do game, which is fine in law, but it's not fine if your pursuit is excellence, if your pursuit is client perfection. And so I had to start my own firm. I had to do this. And frankly, I had to engage CRISP because they appeal to me as a company who themselves seek perfection. And if you're going to be perfection, if you're going to be excellent, you have to seek out people who are also seeking out excellence, who are also seeking out perfection. And that is what I found in CRISP. That's what I am, and that's what I'm building, and that's where I've come from.